and welcome to this meeting of the Local Review Body of 11th of September 2013. I can confirm that the meeting has been properly called and is quorate, and I would now first ask, members to appoint a chairman for this meeting, please.
Could I nominate Councillor Nicholl?
A seconder for that?
I'm more than happy to second that.
I'd like to remind everyone present that this meeting will be recorded and that the recording will subsequently be available for public listening. Okay. Take it we're complete, so there's no apologies. Claire, anything else you want
No
to say?
No apologies, Chairman.
Any declarations of interest on any of these items before us? No declarations of interest. You lead us through the procedure.
Thank you, Chairman. I can confirm there are 5 notices of review for consideration at this meeting. The options available to the local review body for all the cases today are that it can decide it has sufficient information before it to enable it to determine the review today, request further information in the form of written representations, resolve to hold a hearing, resolve to hold a site visit, or if the local review body resolves that it has sufficient information and that no further procedure is required, then the local review body has the full powers to uphold, reverse or vary a determination. A planning advisor will be present to assist for each item on today's agenda. It is confirmed that they have not had any involvement in any of the cases and were not the case officer or the appointed officer for the relevant application. They are purely here to provide independent advice as needed on matters of planning policy, law or process to the local review body. Members all have the papers before them and the summary of each case, and if members are clear and if no further clarification is required, I will ask the Chairman now to lead the debate and in the first instance to lead the local review body through the agenda papers together and decide if it has sufficient information before it to make a determination today.
David, do you want to say something?
Yes, Chair, just to confirm, I will act as planning advisor for the first 4 items, but Janice Kay will be joining us for the last item.
Okay, I propose to go through each one in turn, and we'll go through each section of each one, and then we would have a debate at the end of that procedure, if that's okay with members. Okay. Right, first case before us is refusal of planning permission for change of use of shop to hot food takeaway at 7779 Whitesands, Dumfries. Okay. No slides or anything, yeah? Right, okay. Lead us on.
Thank you, Chair. As ever, the photos which I have are exactly the ones that you have in the agenda papers, which the case officer had. So there's just a couple in this instance. First shot shows the application site from across the Whitesands. You'll note there's a listed building sits behind the frontage. And that's a further shot looking slightly more towards the St Michael's Bridge end. But obviously it's a vacant unit at the moment, but previously was a shop.
Okay, members. In section 1, notice of review, is there anything that you wish to bring up? Any points in that particular section? No? Okay, we'll move on to section 2, which is report on handling. It's determined under delegated powers and related consultee comments. Anything in that you wish to bring up? Councillor Hislop.
Chair, it's down to the fact that we have a planning application here and later on it says there wasn't sufficient information forward. Why was it validated if there's not sufficient information to be able to make the determination?
Basically, the regulations on what can and can't be validated are fairly limited. If you have an application form that is submitted and it's been signed, dated, you've got the relevant plans and you've got the application fee, then the application has to be made valid. If there's any missing information, that has to be sought by the case officer thereafter, which is what happened in this instance.
Nothing else in that. We'll move on to section 3, observations of the appointed officer on the applicant's notice of review. Anything on that? No. Section 4, planning application form. Sorry.
Sorry.
Councillor Hislop.
It was, the last point says that the requested details were not received within the time period. Was there any details came in after the time period?
No, because the application was determined and there's been no new information submitted with the notice of review either.
Okay, section 4, planning application form dated 13th of March 2013 and the plans. Anything on that, gentlemen? Everything in order? Okay. And section 5 is the decision letter from the Dumfries and Galloway Council dated the 20th of May 2013. Fairly straightforward. And section 6 is relevant extracts from the Dumfries and Galloway Structure Plan and Nithsdale Local Plan. Nobody get any points. Okay, the decision was to refuse on the grounds of on the insufficient information in respect to the details of ventilation system, including external flue, has been provided in order to allow the planning authority to properly determine this application. Anybody wish to say anything? It looks to me as if it's fairly straightforward, but anyway, Councillor Hislop.
Chair, the planning application didn't have the information. We don't have the information in front of us with regard to the external flues. So I think the decision of the planning officer was the right decision to make, and I would refuse the appeal.
I would be in agreement with that. Anyone otherwise minded? Councillor Thompson.
I think the applicant has indicated that the exhaust system will be similar to that of an adjoining property. I think the question that's in front of us is whether that's sufficient for us to grant approval if we added a condition that full details would be required before the premises are brought into use. And I would actually seek some advice on that.
Suspensive conditions can be used as a method of being able to approve an application without full information, but it depends on the significance of that information which is missing. My reading of this was the case officer felt it was absolutely fundamental to know whether you were talking about big flues, small flues, whether they could be in the valley gutter. It was just insufficient information to be able to determine it, is my reading of this. It's not the fact that it couldn't be acceptable, but we just needed to know what we were actually dealing with. So the difficulty is, if this was approved with that lack of information, the suspensive conditions could come in and you found that you had a wholly unacceptable metal flue coming up to a degree that was intrusive in the conservation area. But by the fact you've approved it, you therefore are going to be in a difficult position to refuse it. Really what this comes down to is, does the LRB feel that they have enough information to determine it? And do they feel a suspensive condition could address that? The case officer didn't feel that they were in a position to approve it without knowing these details.
Yes, thank you for that advice.
Councillor Cole.
Thanks, Chair. The applicant states that they are not in a position to determine the final details of the ventilation system because they require to address building standards and environmental health issues. Does that not actually make it extremely difficult for them to put in these details in the application?
Well, basically a fully worked up scheme that is going to meet all the requirements is what arguably should have been submitted, because that way if you had an application for the change of use and all the alterations that the agent knew was going to be able to get a building warrant and clearance from environmental health, it would have actually smoothed the passage through for their client. So I don't think there's any fundamental issue about a hot food takeaway in that location. There is, as you've seen in the photos, a Domino's pizza next door. So the principle of it is okay, but the detail was really what was required to be able to determine this. And I would have thought on that basis it would have been reasonable for them to have worked up a full scheme to enable all parts of the council to be able to determine it together.
Councillor Gold.
Presumably it would have been sensible to discuss these issues with environmental health and building standards prior to submission of their plan.
I couldn't disagree with that comment.
Right, we have a motion. Anyone otherwise minded? Motion to dismiss the appeal? No? Okay, clear.
Chairman, the decision in respect of item 4, 77 to 79 Whitesands, Dumfries, refusal of planning permission for change of use of shop to hot food takeaway, case reference 13P30182, is to uphold the decision of the appointed officer in refusing, on the grounds of refusal, that insufficient information in respect of the details of a ventilation system, including external flue, has been provided in order to allow the planning authority to properly determine this application.
Thank you. Move on to the next case in front of us. It's a notice of review in respect of refusal of planning permission for erection of raised decking platform and associated staircase to the rear of a property, retrospective, at Railway Inn, 36 St John Street, Whithorn. Mr. Sutty, are there any slides on this one?
Yes, these are the photos you have on page 131 to 134, which were, again, the case officer's slides. That's looking to the rear of the property from the rear lane, and as you can see, it's already in situ. It's a staircase, but it does also have a decking area at the top outside the door. Moving further in lets you see the finish and the materials a bit more clearly. The next photo moves to the other side under the decking, looking back. That's the view from the back lane looking to it, so it is clearly visible from the back lane. The next few shots were taken from the decking itself to give you a view of one of the issues, which was overlooking. So this is looking to the rear of properties across the back lane, and then looking further along on the decking itself, you can see down to the back lane. And from that, turning to left, you can see that's the objector's garden that was concerned about overlooking. And turning the other direction, that's looking down the rear of the gardens that lead down the back lane.
Okay, thank you very much. Section 1 is a notice of review dated the 22nd of February 2013 and related documents submitted by J.R. Brown Building Design, agents for Mr. Lee, the applicant. Is there any matters you want to question or bring up on that? Councillor Hislop.
Do we know what the standard would have been for a fire exit at this door? Because it seems quite a large decking area for a fire exit.
That would really be a matter to do with fire regulations and building standards, so I'm no expert on that, but I think, just going back to a couple of the photos, in my mind it's quite clear that it actually goes a bit beyond that. If you actually see the scale of the decking area, it's more than just an escape ladder. That photo, I think, that photo there shows how it extends to the side, so it does go more than just the bare minimum necessary for an escape.
Are we allowed to ask how long it's been up?
That I don't know, but it was certainly an application which came in at the end of last year, so I would guess it's been there around a year or so, but if you actually look at one of the photos, there's a bit of green on some of the timber. Yeah. Yeah, so it looks like it's probably been there a little bit longer. It has to have been carried out within the last 4 years, or it would be immune from any enforcement action.
Okay. Councillor Blake.
Just regarding it being used as a fire exit, is it not rather unusual to have a timber fire exit?
Again, I'm not an expert in the building standards things, but it would seem counterintuitive to use timber as a fire escape.
Yeah. Councillor McComb.
It does strike me that there is an excessive amount of decking there. It looks to me much like a veranda come fire escape. On page 109, you can actually see wooden seating on the veranda section.
We'll get to that later on, Councillor McComb. If there's no more on section 1, I'll go to section 2, which is report and handling, determined under delegated powers and related consultee and representative comments. Pages 83 to 92. 89 or 90, 91, page 83 to 91. I see in that, under 1.2, planning permission was granted previously for extension to lounge and formation of toilets on the 12th of January under reference 95, etc. No other known planning history. Does that mean that the part of the building this is attached to does not have planning permission?
That I don't know. Basically, that's the planning history that the case officer will have established, but whether or not that was part of that application, I don't have those plans to hand, I'm afraid.
Okay. There's no other questions on that. We'll move on to section 3, observations of the appointed officer on the applicant's notice of review. I think Councillor McComb's point is on page 95, 1A, safety. It's apparent that a development is not just a staircase. The main element of the development is the extensive raised decking area with the stairs ancillary to it. And that's the point you were making, Councillor McComb. Anything other than that? Section, if there's nothing else, I'll move on. Section 4 is the planning application form dated the 7th of November 2012 with the relevant plans. There's nothing there. It's up to page 109. You're happy with that? You have no points. Section 5 is decision letter from the council, the Dumfries and Galloway Council, pointing out the reasons for the refusal on page 114 and 115. On section 6 is the relevant extracts from the Dumfries and Galloway Structure Plan and the Whithorn Local Plan, taking us from page 117 to 128. And the last section is the relevant photos of the application site and locality, which you've already seen on the screen. Have you got sufficient information to make a decision on this? Reach a conclusion? And if you have, what's your conclusion? Councillor Thompson?
I think the size of the decking area is the sort of main consideration, and the overlooking of other properties. While I have some kind of sympathy for the view that says that it's not particularly an attractive view at the back of these buildings, like, you know, it's fairly clear to me that the reason for a fire escape hasn't actually been met by that particular structure. You know, it's clearly a structure that's intended for people to sit out on. I think the officer's recommendations are correct and we should refuse this.
Councillor McComb?
I would accept the fact that you do require some form of fire escape here, but what has been provided to my mind is excessive. I don't find it particularly out of keeping with the backland development which has taken place. I mean, it is described as an outstanding conservation area, but I think it falls within the boundary of the outstanding conservation area, and the sheds and garages you see there, I would say in actual fact the decking perhaps is an improvement on some of the things you see. But the development, to my mind, has been excessive. Certainly there is a degree of overlooking which I would find unacceptable, I think the second reason for refusal, most definitely, I would support. I'm not so sure about the first one.
Any other comments? So are we agreed that we're going to refuse the appeal? That's the first thing. Do you wish to amend the reasons for refusal?
I would certainly suggest that the first reason be omitted.
Councillor Blake?
Having looked at the papers, I'm quite happy with both reasons remaining.
Councillor Thompson? You were happy, I think, with both reasons, were you?
Yes, I was actually happy with both reasons, though, as I said, you know, I had some sympathy for the view about it being an outstanding conservation area at the rear of the property.
I'm inclined to agree with you. I think, you know, there is a need, there's obviously a need for a fire escape probably, but a wooden fire escape is not a particularly good idea. Anybody Jim, Councillor McComb, do you wish to make an amendment? Or?
I think I'm out on my own in this one. At the end of the day, I would still recommend refusal.
Okay. Anyone otherwise minded? No. Yeah.
Chairman, thank you. The decision of the local review body in relation to item 5, Railway Inn, 36 St John Street, Whithorn, reference 12P10337, is to uphold the decision of the appointed officer and that the application be refused on the following grounds. 1. The design of the decking so far as external appearance is concerned and its proposed siting is detrimental to the character, appearance and visual amenity of the Whithorn Outstanding Conservation Area, such that it is contrary to Structure Plan Policy E8, Local Plan General Policies 1 and 50, Supplementary Planning Guidance Number 2 and the Council's Caring for the Built Environment Guidance. Reason 2, the decking, by reason of the unacceptable and oppressive level of overlooking which it permits to neighbouring properties, is contrary to the provisions of Whittown Local Plan General Policies 1 and 19 and the Council's Supplementary Planning Guidance Number 2, Design Guidance for the Built Environment, on the grounds that it gives rise to a significant loss of neighbouring residential amenity.
Thank you. We'll move on to the next case in front of us, which is notice of review in respect of refusal of planning permission for installation of 8 replacement windows with white double glazed UPVC to the front of the dwelling house at 31 High Street, Lochmaben.
As ever, the same photos that you have in the papers. This is the view on Lochmaben High Street, so you can see that the original windows are still in this building here. Some of the other shots show how the High Street has been changed quite legitimately. There was never what's called an Article 4 direction in place in Lochmaben Conservation Area, which meant until the legislation changed earlier on last year, then it was permitted development for people to change their windows. And as you can see, many, if not nearly all of them did. The far end one there, you can see the white building, that does have original windows, and having been up and down the street, there are 1 or 2 others, but the vast majority are being subject to replacements as permitted development over time.
Excuse me. Section 1 is a notice of review dated 28th of May 2013, submitted by John Gordon Associates Limited, agent on behalf of the applicant, Mrs. Little. Is there anything in there that members wish to comment on or ask questions about? Is there any real problems with that bit? Section 2 is a report on the handling determined under delegated powers and related consultee and representative comments. Is there anything in that? Councillor Thompson?
Yeah, just on page 149 of 354, 48. The Scotland Amendment Order 2011, I think, is the sort of relevant part of this. And the question I have on that is, the other properties in that street, should they subsequently require to replace these windows, would that particular amendment apply? In other words, would they be required to conform to the original sash windows?
This change basically just says that now in conservation areas there are no permitted development rights. So if they're doing anything which materially affects the external appearance of the building, it now requires planning permission. So if you have, just going back a slide, for example, if one of those properties there that had UPVC windows was wanting to, so the windows had ceased to function properly, if they were replacing like for like existing UPVC with other ones, that's not development. So they wouldn't actually require. What the intention of the Scottish Government was, as I understand it, was to allow people to extend more in non-conservation areas, but to actually give a greater weight to the fact that if you have a conservation area, you're looking to try and retain the character of what was there. Whether or not you feel the Lochmaben High Street has already had its character changed over the years by the lack of an Article 4 direction is it's obviously open to interpretation. But no, in short, if you did need planning permission to change windows from existing timber to UPVC, there would clearly be I suppose officers wouldn't want to see that happen, but if the building has already been subject to changes, then they may not even need planning permission.
Just to be clear in my own mind, because that was quite a lengthy response.
It's a complex issue,
yeah.
Sorry.
You know, for example, these UPVC windows that are displayed in that photograph, if someone who occupied that house required to change them, they could actually change them for exactly the same type of window.
That's right. A like-for-like replacement is regarded as a repair. It's not development. It's only when you're making a material effect to the external appearance that constitutes development. So in other words, it's got to look different. So UPVC for another UPVC that looks the same, no problem. Ironically, if you were wanting to take UPVC windows out and put timber sash and case ones in, that would actually need planning permission, but I wouldn't imagine there'd be a problem.
Is it the PVC bit of the sash and case bit that's the problem?
Basically, if you go back to the original photos, you can see that, I think that photo probably shows it, there is a relief. You can see the difference between the upper sash and the lower sash, whereas UPVC windows are bulkier, they don't have the finer wood astragals, and you see them as a single plane. So they clearly do read as a modern window compared to the original ones there. So you can actually get UPVC sash and case windows that look pretty good, and we have, as a council, accepted those in some areas of conservation areas. Not in listed buildings, but this isn't a listed building.
That'll be £10 to the chairman's lunch fund. Going at it again, Jim. Thank you for that clarification. Is there anything else in that section? No. Okay, observation of the appointed officer and applicant's notice of review. Is there anything in there that people are concerned about or wish to ask clarification on? No. Okay. Comments of the applicant on observations of the appointed officer. No. Okay, we move on to planning, section 5, planning application form dated 27th November 2012 and the plans, relevant plans. No. Okay, section 6, a decision letter from Dumfries and Galloway Council dated 6th of March 2013. Okay, section 7 is the relevant extracts from the Dumfries and Galloway Structure Plan and Annandale and Eskdale Local Plan. Okay, and section 8 is the photos of the application site and the locality, which we've seen. In fact, we have one up on the screen at the moment. I thought the house had a sloping roof, but it's just a photograph, it doesn't go high enough. Any comments to make, members? Just to remind members that the grounds for refusal were that the proposed development is contrary to Dumfries and Galloway Structure Plan Policy E8, Annandale and Eskdale Local Plan General Policy 50, and the advice provided in Historic Scotland's Scottish Historic Environmental Policy, or SHEP for short, and Supplementary Planning Guidance number 2, design guidance for the built environment in that the materials and detailing of proposed UPVC windows would adversely affect the character and appearance of the building and surrounding Lochmaben conservation area. Any thoughts? Councillor Blake.
If this had been an area where all the existing houses were wooden sash and case, I could see a reason for supporting this. But I've certainly got a certain sympathy in this case that making it wooden sash and case would probably make that house stand out more in the street compared to the rest. I'm just not sure on planning terms how we can get around that.
Yeah, I mean, Councillor Hislop.
Yeah, I think the one with this is the fact that what they're looking for is tilt and turn windows, which to me would sort of possibly stand out a bit more. However, there are opportunities to get UPVC ones, and I think they can put, maybe Mr. Sutty can keep me right, but I think they can put astragals in them to split up the windows. So, whereas I'm not keen on the idea of the losing sort of sash and case, get that right one of these times, window, I wouldn't be opposed to them being UPVC, sash and case windows.
Yeah, I came across this recently with my own house because I was thinking of replacing a couple of windows and discovered there was a Grade B listed house I lived in, and the wooden sash and case I had in. My planning officer told me what I couldn't do. But we never haven't gone down that way. We're just going to replace the panes. Anyone else wish to comment? Councillor McCall.
Thanks, Chair. I think this particular applicant has been a victim of the recent change in emphasis on the conservation areas. Had this application come in fact, it would not have required planning permission in the past. It's only recently that the permission has been required. You've got a situation here where the bulk of the houses have already been changed to UPVC. And in actual fact, from the look of them, they appear to be tilt and turn windows as well. That this house is now very much the exception. When you look along the streetscape, this is the only one with the original 1930s windows. I think on the first floor, yes. The applicant does claim to be the only house now with the original windows.
I can confirm I have gone along Lochmaben High Street just to check. There are others. The one that you see at the end there is certainly one. There's another one on the opposite side of the road further along. But it's undeniable that as the photos demonstrate, there's a considerable amount of quite legitimate replaced windows along the High Street. I mean, my reading of this is to a degree just what Councillor McComb said is correct. It's a change in circumstance in national legislation. Perhaps the question you've got to ask as an LRB is this trying to close the door after the horse is bolted? Is it too late? Or I think what the case officer was trying to do here, the appointed officer was trying to put a marker down that these didn't require before, they do now. It's a line in the sand. That said, I'm aware that the council has accepted double glazed UPVC sash and case windows in conservation areas. So it's not putting head in sand and saying, no, you must retain your timber single glazed windows forever. There's a balance to be struck between energy issues as well. Obviously, double glazed windows work better as far as energy retention's gone. So I'm looking at the reason for refusal. It's quite clear two things. Firstly, that there's a second-degree effect there that shouldn't be there. But also, it is looking at the detailing. It's the materials and the detailing. So in answer to a previous question, it's not just the fact it's UPVC, it's also the detailing, which you can see on page 173. If you're going to have replacement windows, are these ones the type of windows that you'd be wanting to see in a conservation area?
Going quiet, up. Councillor Hislop.
Chair, it's down to the fact that if I had a planning application in front of me today that had the UPVC sash case windows, I would be looking at it differently than I would the current proposal of the tilt and turn or the open at top ones that we currently have. Can we put that condition on? Because we're actually then looking at a different window. And it's to the fact that I don't know if the company that's actually provided these plans can deliver different kinds of windows, as in sash and case, UPVC windows. Because I would have been minded to support UPVC sash and case windows rather than the tilt and turn ones. I would be, because we would have the detail in the planning application here, to put a condition on to do that, we don't know what we're actually going to get because we don't have it in front of us. And I'm just wondering if it's safer maybe then to actually look at a refusal today, but then would that mean it would go through the same process again because the officer would view the UPVC not suitable, therefore it would come back again, and I think that would be a little bit too onerous on the applicant to have to go through that.
I was just checking the decision date, but it's the 6th of March this year. So basically they get another go within a year. As I've said earlier, it has occurred in conservation areas quite regularly that UPVC sash and case double glazed windows have been accepted if they're the appropriate design. I don't think you could reasonably approve the permission with a condition that they've got to be something different than what you're seeing. I think you're quite right. What you see on page 173 is what they have applied for. And to do anything else significantly different from that, as sash and case would be, I would say is a materially different proposal. So they would need a further application, but it's within the year. It's one of these things where in the minute I think you could clearly note that the view of the local review body was of the opinion that appropriately designed timber sash and case windows, double glazed, would be acceptable in this location, but the actually applied for windows aren't appropriate now due to the legislative change that's come in. That would be an option to you, but I don't think you could condition it.
I think Councillor Thompson and I actually were on a previous case where we went for UPVC sash and case windows as an LRB appeal. I would be. Would another application within the year be free of charge?
Yes, that's correct. That's why I was checking the date. So provided it came in before the 6th of March next year, there would be no extra fee.
Councillor Thompson.
Yeah, I mean, I think the materials of construction are something that, you know, it's a debatable point, you know, in these modern days. You know, you do have to use materials that are less than traditional. I think the applicant in this case is between a rock and a hard place. A couple of years ago, you know, there wouldn't have been any need for that. However, we have to deal with what's in front of us. And what's actually in front of us is, in fact, a window system that looks out of character. So on that basis, I'd be inclined to refuse the application.
Yeah, I mean, you know, times move on, things evolve, and I know that my wooden sash and case windows at home the thermal efficiency is not very clever because the gap between the panes of glass is very small. It's only 4 mil or something. Whereas nowadays they're looking at 15, 20 mil between the panes of glass to give them better thermal efficiency. So, Councillor Blake.
I thought you'd forgotten me, Chairman. It's just to clarify something David said. It may just have been a slip of the tongue, but you actually said that appropriately designed timber windows. Just to clarify, it's UPVC windows.
I'm like a stuck record. Yes, I did mean appropriately designed UPVC double glazed windows. My apologies.
It's Ivor's tongue that slips when he tries to say sash and case. So, where are we with this one? I think the feeling is that we refuse the application as it stands, or refuse the appeal as it stands, but we put a note in, am I reading the company correctly, that the case officer should look at UPVC double glazed sash and case windows if a subsequent application appears.
That's pretty much it. I mean, you'd be minuting that you don't consider the currently submitted application to be appropriate in the conservation area, but you would request that should a further application come forward, then officers should look sympathetically towards UPVC double glazed sash and case windows instead.
Members happy with those? Councillor McComb?
Yes, I would hope that the applicant could be encouraged to submit a reapplication in the near future.
Yeah, an agent should be aware of the planning regulations and the fact that they can submit it, but when you write to inform them of the decision here, presumably that could be appended to the letter.
Yes, and basically the decision letter has to set out the thinking of the LRB, so that will be incorporated into the actual decision letter that would go out.
Happy with that? Okay, Claire, can you put that in words?
Mm-hmm. Thanks, Chairman. Decision in respect of item 6, 31 High Street, Lochmaben, reference 12P40354. Decision of the local review body is to uphold the decision of the appointed officer and the application be refused on the grounds that the proposed development is contrary to Dumfries and Galloway Structure Plan Policy E8, Annandale and Isedale Local Plan General Policy 50, the advice provided in Historic Scotland's Scottish Historic Environmental Policy, and Supplementary Planning Guidance Number 2, Design Guidance for the Built Environment, and that materials and detailing of the proposed UPVC windows would adversely affect the character and appearance of the building and surrounding Lochmaben Conservation Area. We also wish a note to be added to the minutes and the notice to the effect that appropriately designed UPVC sash and case windows would be acceptable if a subsequent application was submitted, but the current windows don't comply with current legislation. Word that appropriately for the decision notice, though.
Aye, maybe slight modification to your wording, but you'll take advice. Good. Right. Okay. We'll move on to the next one, which is notice of review in respect of refusal of planning permission in principle for erection of a dwelling house, agricultural building, formation of a loch and access track at Fulton Moor, Amesfield, Dumfries. Mr. Sutter, the photographs for this.
Thank you. Yes, this obviously wasn't taken earlier today. This is from a view just beyond the 701, looking across towards the application site, which is pretty much in the centre. And that's from the same position, just a zoomed shot in. So you're looking across the 701 there. Going further down that road, you're going towards, you can see the farmhouse, Fulton Farmhouse is the white building just to the left of centre there, and a zoomed shot, which is zoomed shot from the same position. and then carry on down towards, just that's the 701 there, looking across there to the land in question, round about the centre of the slide.
Just to get my bearings here, we're looking from the southeast side of the A701?
That's right, yes.
Right. Looking up towards A Village.
That's right.
Right, I'm with you.
And then this has gone across the 701 now, and this is the more minor road. Got the number of it here somewhere. That's the C6N road. And you can see the site is to the left-hand side of the road. This photo is showing where the access road would come in. It would come through the trees, I understand. And flipping back further along the road there, that's looking in the opposite direction to where the access point would be. And then the final slide is looking up towards the application site itself.
Okay. Right. We'll go through the sections here. Section 1 is a notice of review dated 26th of June 2013 and the related documents submitted by GM Thompson, agents for Mr. Morley, the applicant. Is there anything in these that people wish to bring up? Councillor Hislop.
Chair, I find this kind of difficult one here. I don't know, is it the applicant who's moving into the farmhouse, or is it the proposed additional labour units? Down to the fact that later on in one of the papers it states that the applicant will be providing one labour unit. Now, he currently stays on the property at Glenea, so therefore, are we looking at 1.5 for additional labour units, or are we looking at half a labour unit? And I find it difficult to just sort of pick out, is this business going to be run separately or sort of conjoined?
You might have noted that there were previous applications on this, which was actually withdrawn, and that didn't have the Glenea land included within it. That was then withdrawn, and a further business case came in including it. So my reading of this is it's a conjoined farm unit on two different pieces of land. That's something which we'll probably come on to further on, but if you look on page 232, it explains that it says subject Glenea, owner Mr. S. Morley, and then goes on about background. Glenea Estate is located 2 miles northeast of Innisfield and is in two parts. So it does make mention of Glenea and Fulton Moor. So my reading of this is that they're looking to have it as a farming business, incorporating the whole farm being the 2 units.
Okay. Councillor McComb, on this first section, is it, Jim?
No, I'll leave it till later.
Okay. There's nothing more in the first section. Yeah. Okay. Section 2 is the report on handling determined under delegated powers and related consultee comments. Any comments on that? Okay, there's no comments on that. Observation of the appointed officer on the applicant's notice of review. Page 221, 222. There's no comments or questions on that. We'll move on to the planning application form dated 13th of February 2013, with the plans and supporting documents. That's from 225 through to 225 to 258, which is including the labour requirement report and justification. Councillor McComb.
I'm seeking clarification of who actually lives in the property Glenea. It states on page 233, currently occupied by an employee of the client's security business.
That's actually one of the fundamental issues with this review, I'd suggest. If you read that statement there and look across the page, I can completely understand why the case officer had read it that all of the land was in the ownership of Mr. Morley, the applicant. Because if you look at page 232, that 2.1 says owner Mr. S. Morley. And you then go across to 2.3 and it says Glenea, the lodge. This property is currently occupied, doesn't say anything about the owner, is currently occupied by an employee of the client's security business and is not available to the farming enterprise. For security purposes, however, this cottage provides an on-site presence at Glenea. So it's, I think, kind of a reasonable assumption to have been made by the case officer taking these two things together, that the lodge was in the ownership of the applicant. But we've now got, as you'll have noted on page 201, a confirmation that the lodge, it is not owned by our client. So the applicant isn't the owner of the lodge, which does raise an issue about the actual grounds of refusal, but we'll maybe come on to that later.
Does that answer your point, Councillor? Is there anything else, members, in that section? We can come back to it if you want, Councillor Bislett.
Just with regard to the site, it says it's 1.99 hectares. That in the application form. Proposed site area of development is 1.99 hectares. That would suggest that's the site. My recollection of planning applications, if it was for an agricultural business, wouldn't you include the whole farm so that you could impose a condition like sort of section 75 tying the house to the actual farm rather than just to 1.99 hectares?
You would normally expect in a case like this the entire agricultural holding would be submitted, because you're right, it would normally be bound by a section 75 agreement to the land. There are details again on page 232 which gives the size of them. I'm wondering as well if on page 233 they've mixed up acres and hectares, because they seem to contradict each other. Oh, that's just the cropping maybe. Yeah, but certainly that's the acreage and hectarage that we've been given there, but you would normally expect the entire unit to be submitted.
Just a wee point on the acreage. According to my calculations, 53 hectares is not 169 acres. I think it's closer to 130 acres.
Multiplication is 2.47, I can tell you that. So, what did you say? 59, did you say? 53. Well, that's certainly an anomaly. Yeah, that's 130.91. Start delving into these things, you sometimes find others. Councillor Hislop.
This is possibly another one. Table at 3.3, estimated labour requirements. You've got 2,645 at the bottom there, net hours. Yet in the next sentence it says the above figures do not include the labour units required for the proposed law. But my reading it, they're clearly in there. So that kind of confuses me a bit as to whether they're in or they're out. And then we have the other one. Who is actually moving in here? And are we looking for an additional house on the Glenea estate, which includes, I would think, Glenea Big House, because the client will be filling one labour unit. Now, is this to put a 0.55 worker in a house? Or is this going to be, as I said, a separate business where you're looking at 1.5 units and the client will be moving into that house?
Yeah, I don't think this is a particularly well written justification business plan. And we've already picked out one fairly large anomaly, and members are confused about other figures in it. Anyone else got anything they wish to say? Okay, if there's nothing else in that particular section, we'll move on to the decision letter. Happy with the decision letter that was sent out by Mr. Rogers. Section 5, Section 6. Relevant extracts from the Dumfries and Galloway Structure Plan and Nithsdale Local Plan. Happy with that? I'm going too fast. Give me a shout, gentlemen. Section 7 is the photos of the application site and the locality, which we've seen on the screen. So, is there anything the recommendation was for refusal, or the recommendation wasn't, but the grounds for refusal were that it has not been demonstrated a new house at Fulton Moor, Amesfield, is essential for the needs of prospective agricultural business due to the existence of another housing opportunity within the land proposed for the said business. Additionally, the proposed dwelling house would be linked with a partly agricultural business, the scale and prospective nature of which does not necessitate the erection of a dwelling house to facilitate a 24-hour presence. Accordingly, the proposal is contrary to the policy of the Council as stated in the Dumfries and Galloway Structure Plan Policy D4 and the Nithsdale Local Plan General Policy 15, which permit the erection of new houses in the countryside only in special circumstances identified in development plans, and none of these circumstances apply in this case. Councillor Hislop.
Chair, it's with regard to the 24 hours presence. This seems to be something new that's come on. My understanding, the justification had to show that there was a sound economic case for a viable business to be put in place. Now, the 24-hour thing, that seems to be something new that's come on to our consideration. You know, because if you have a farm, it's always went with a farmhouse as long as you could show that it was necessary to have a farmhouse there and it was economically viable. I'm just wondering where this 24 hours, 24/7, because I don't know anyone who can work 24/7. They could be on site maybe, but I don't think they would be working. Some sleeping, etc. would be there as well.
So I once told a man who was complaining that he had, well, not complaining, commenting, he had a big responsibility. I said, well, there's only 24 hours in a day. And I said, you work 8, you sleep 8, and you've 8 to yourself. So, in round figures. And he didn't particularly like it. Have you any comment to make, David?
That's correct. Basically, structure plan policy D4 looks at it to be an essential house at that location rather than just desirable. There isn't a mention within there about the need for 24-hour supervision. I suspect that came around because very often it is claimed that there's a need for supervision on site for security purposes, and obviously you've got the fishing loch going to be potentially stocked with about £5,000 worth of fish, and I think that was maybe the argument that was being put forward. Certainly I did note that the case officer had made some comment about that if security was the concern, then there's other methods which don't necessitate a permanent on-site presence. Similarly with the grey squirrels, I don't think that really requires an essential need for a house. But these were additional things that were getting thrown into the mix, as well as the agricultural side of things. But no, there's been no change in policy or wording of that. The supervision, I think, was just to make it clear in terms of the security element that was put forward.
Are members happy to stand by the decision of the officer? Or is there any change to that you wish to make? Councillor Blake?
Yeah, David said that there was an issue because of the statement given that the second property was under the ownership of the client. It's clear that it's not, although there is a bit of contradiction there because it does state at 2.3 that the property is currently occupied by an employee of the client's security business. It makes the ownership of that property quite questionable.
Yeah, it's back to the justification statement which has got anomalies in it, or mistakes in it. Councillor Hislop?
There's that one. There's also the fact that there was reference to the lodge as suitable, so that means another house. Are we actually taking into consideration, is Mr. Morley's house included in this? His current dwelling house or not? And therefore, if he is going to be supplying a full labour unit on his current house, that means we're looking to put in a 0.55 labour unit justification for a house. If he hadn't put that in, I would say that with the amount of land that's there, there is a justification for a farmhouse. And the additional business of the fishing, I think, adds hours to it to give you the justification, whether you need to be there 24/7 or not. But I think there is that in there. But if he's supplying one of the labour units, I don't know if we could justify a second house for that on that land, which would only be half a unit. Therefore, is it a viable house to have half a unit on? Could you survive if you're only working 20 hours a week on a house in there? I would doubt that that would be viable.
Logic there somehow. Councillor McCobb?
It is clearly stated in page 201 that the applicant does not own the other property, which is the lodge, I believe.
Chair, there's Glenea Big House, there's Glenea Lodge. The lodge is at the road end. Now, Glenea Big House is a baronial house or whatever. It's the estate house. Now, has that one been accounted for or not?
I could be wrong, but my reading of the business case is it's not included in it, which possibly means that the justification given by the case officer was correct then, even if you disregard the lodge. Because you've obviously got within the overall unit of Glenea and Fulton Moor another big house that's already there.
Okay. Councillor McComb, did you wish to say something?
I'm just not sure, Chair, having listened to the discussion, that we have sufficient information here. I'm just a wee bit concerned about the uncertainty of the accommodation figures, accommodation arrangements being mentioned, and indeed about the size of the holding and its labour requirements.
We've got information, but I'm not sure it's accurate. And I think it's a badly written justification. But so, are we happy to stay with the recommendation, with the grounds for refusal? Or do you wish to add to them? Or do you wish to change the decision? Councillor Hislop.
Chair, if this was an application for the 2 parcels of land tied in with a house, I would look to actually change the recommendation. I think there is a justification there. Currently, it's based on 1.99 hectares. There's no mention of other land within the application site. So I'm struggling with the business case which says that the current client, who, according to this, resides at Glenea, I'm struggling to actually turn it over. But I think if it came in differently, I know how I would have put it in, to keep it a separate business and it's going to be run as a business separately, rather than tying it into, I must admit, squirrel hunting didn't really come into me as an agricultural need. But I think the other parts, I would have seen a reason for it. However, the business case doesn't actually stack up according to this. And that's where I have my problem. If it was just, I'm planning to create a farm with these 2 parcels of land, putting my buildings here, etc., that justifies a house in my view. But currently, the way it's written, one of your labour units is going to be supplied by the client who resides at Glenea. And that's where I have the problem. I don't think it justifies a house for half a unit, but it does for a full unit.
Yeah, I mean, if this had come in as an application for the farm and not 1.99 hectares, if taken in the whole farm, it would have been a major application to which a Section 75 would have been attached. If it had been a major application, it wouldn't have come to us if it had been refused by the delegated powers. So, Councillor Thompson, did you wish to say something? No. I am happy to go with what's been the grounds for refusal as they stand, because I think there's too many anomalies for us to change anything here. That's my opinion. And I don't know how other members feel. Councillor Cole.
I think it may be as well to support the officer's recommendation, and perhaps the applicant may resubmit a more detailed application in the future, making it very clear what the labour requirements are and what the accommodation arrangements are as well.
Sorry, you're looking for the decision date there. That was the 24th of April. The only thing that does ring a bell is I think this was a repeat application, in which case, yes, this is a repeat application, in which case there wouldn't be a free go, but obviously it's open to the applicant to decide whether they would wish to go away, regroup and come back with another application anyway.
Okay, are members content with that, or do they wish to make any amendments? Claire?
Chairman, the decision of the local review body in relation to item 7, Filton Moor, Amesfield, Dumfries, is to uphold the decision of the appointed officer that the application be refused on the following grounds: that it has not been demonstrated that a new house at Filton Moor Amesfield is essential for the needs of the prospective agricultural business due to the existence of another housing opportunity within the land proposed for the said business. Additionally, the proposed dwelling house would be linked with a partly agricultural business, the scale and prospective nature of which does not necessitate the erection of a dwelling house to facilitate a 24-hour presence. Accordingly, the proposal is contrary to the policy of the Council as stated in Dumfries and Galloway Structure Plan Policy D4 and Nistale Local Plan General Policy 15, which permit the erection of new houses in the countryside only in special circumstances identified in development plans, and none of these circumstances apply in this case.
Thank you, Claire. We now move on to the next item on the agenda, which is notice of review with respect to the review of condition 1 of planning permission 13P20097 for the erection of stable block and screen fencing at land adjoining Springhome House, Springhome. Mrs. Kay.
Thank you, Chair. I'll now run you through the photographs. Directly in front of you, on the left-hand side, beyond the white car, you will see the fence which is the subject of this review. On the right-hand side, many of you will recognise this. This is the main trunk road going through the middle of Dumfries and Galloway. This is a view taken from across the street, looking directly at the fence. Then moving up further along and looking back towards the property, you can still see it's from across the other side of the main road. And you can also see the bund on the right-hand side, which is referred to in the documents. Another view, getting a slightly wider view, looking to see how it relates to the traffic generating coming from the Sederunt direction and going towards Castle Douglas. This is going into the site, so you can actually now see the rear side, looking across on the other side of the property, on the other side of the trunk road. But you can see how the bund goes up towards the fence. Another internal view. Thank you, Chair.
Thank you, Mrs. Kate. Move on to the sections in the report. In the section 1 is the notice of review dated 2nd July 2013 and related documents submitted by Dorothy King, applicant. Is there any questions in that you wish to bring up, members? Anything, gents? No? Okay. Section 2 is report and handling, determined under delegated powers and related consultee and representative comments. Page 303 to 312. Councillor Hislop.
Just with regard to page 311, do we know if Mr. Shackleton actually spoke to the applicant before he emailed back the last one, which says happy with this sort of condition? Following recent emails, I would be pleased if you take the action you suggested and that the application is recommended for approval with a condition attached regarding the height of the fence.
I can't confirm one way or the other.
Okay. Section 3, observation of the interested parties and the appointed officer on the applicant's notice of review. That's That's 313 up to 322. Okay, if there's nothing in that section, I'll move on to section 4, comments of applicant on observations of the interested parties and the appointed officer, which is 323 to 328. Section 5, planning application form dated 20th of March 2013 and the plans. Section 6 is the decision letter from the Dumfries and Galloway Council, Mr Rogers. And section 7 is the relevant extracts from the statutory local plan. And section 8 is the photos of the application site and the locality. Okay, happy you've got enough information to come to a conclusion in this? There's no matters you want clarified by Mrs Kay? Planning matters? Okay, Councillor Hislop.
There's reference in the document to us making a site visit. My personal view is I've passed that site in a couple of times on my travels up and down the region. I feel that I'm aware of the site and I don't need to make a site visit, so I would move that we do not undertake a site visit at this time.
I personally don't need a site visit because I pass it about 10 times a week. Councillor McComb's in a similar situation. Councillor Thompson.
Yeah, I actually took the opportunity while I was passing by last weekend to actually have a look at that. So I don't believe I require a site visit.
Quite sure you don't either, Blake.
No, I know the area well.
Members, any comments to make on the decision that was reached? Comments to make at all? Councillor McComb?
There is a clear condition attached to the permission that the fence be no more than 1 metre above ground level. And my reading of the email correspondence is that that condition was accepted.
Certainly accepted by the agent. Yes, I would agree. Councillor Thompson?
I think on page 326 of 354, the applicant said that, you know, obviously that she had accepted it, but retrospectively, she would not have accepted it, yeah, if she had had all the information in front of her. So at the time, I think the application was, in fact, you know, the recommendation to reduce the height was accepted. It's the second paragraph on that page. If I had time to properly research that scenario, I would not have been induced to initially agree to the screen fence being cut down to 1 metre, negating the main purpose of it to block the intrusive effects of traffic.
Yeah. Councillor Hislop.
Chair, one of the problems I would say I have is actually, it says it's because of the visual amenity. As someone who drives past there, I hadn't noticed it was there. And I must admit, I don't find it intrusive. It's just something, something for me to be intrusive. Oh, imagine putting that there. But I have never driven by that and said that about this fence. And it's not that long ago, so it's not that I haven't driven past since it's been put up. It's the last couple of weeks. I've been up and down the road once or twice, and I must admit, I wouldn't say it was visibly intrusive.
I would have to say I've noticed it more in the last week or 10 days since I got the papers than ever I did before. Councillor McCall.
I would have to endorse Councillor Hislop's view as well. And even looking at the photographs, I still don't think that it is overly intrusive.
Councillor Thompson.
I mean, it does seem a lot of fuss about very little. We're reducing the height of a fence from its highest point at, I think, 1.8 metres to 1 metre. I don't really see that visual amenity actually comes into it at all. I've passed that site regularly, and like you, I didn't particularly notice it until I actually had the papers last week, and I made a particular point of looking at it. So I've got some sympathy for the residents' viewpoint about the excessive traffic noise in that region. It is pretty dreadful, but that's something that we're not asked to deal with here. So just a comment I'm making on it.
Yeah, the only comment I would make about is the colour of the fence. It's not coloured, it's just wood. It will weather, no doubt, with time. Councillor Blake.
I would totally agree with the previous comments that having passed that, I didn't really notice the fence was there either until I then looked for it. That if the applicant had decided to plant a row of lined conifers, that would have been more obtrusive, but certainly would have been to a significant height. I would also question the deflecting of noise back to the other side of the road. I find that quite hard to accept.
Yeah, so I would agree with you there. I get a feeling that the committee would be inclined to remove condition 1 from the permission. Would that be fair assumption of what's being suggested here by members? Speak to me, please. Councillor McCall.
I certainly feel that 1 metre is just a wee bit on the draconian side. That 1.8 metres, it's on the side of a trunk road, and it's not much higher actually than the hedgerows and the dikes which are there. It just doesn't stand out.
As I come up the road this morning, the hedge between the house and heading towards Castle Douglas, along the field side there, is maybe higher than 1.8 metres. But it is a hedge, and it is softer. But are members happy with that, or do you wish to leave the condition in?
Chair, I would be minded to remove the condition, but maybe make it 1.8 metres so that we don't have something higher going up.
So amend the condition to make it 1.8 metres, so it can't be taken down and another one put up. Janice.
As I understand it, the fence is what has been applied for, and if you remove the condition, then it would allow it to be as approved. So you don't need to address it by adding an additional condition, because planning permission will be required if they wish to change it if it's higher than a metre.
Okay, members happy? Okay, Claire?
Chairman, the decision in relation to item 8, land adjoining Springham House, Springham, the decision of the local review body is to delete the condition 1 as set out on the report, that the fence hereby granted planning permission shall be reduced in height to no more than 1 metre above ground level within a period of 2 months from the date of this permission. Thereafter, no structure over 1 metre in height can be erected at the site without further application for planning permission being submitted. That is being deleted.
Okay, thank you very much. Folks, I have no further business. The meeting's over. Thank you.